versus Raymond Morrison, case number 25CR859. The defendant is present with counsel Bill Watson. We were last here on December 30th, 2025, where the defendant pled guilty to count 1 of the indictment, aggravated possession of drugs, a felony of the 5th degree, in violation of revised code section 292511A with the forfeiture specification, and we are here today for sentencing.
Mr. Watson, any reason not to go forward with sentencing?
No, Your Honor.
Anything you want to say on behalf of your client?
Thank you, Your Honor. May it please the court, I'll be brief. Mr. Morrison has a history, quite a long history, and I know in the past when he's gotten chances on probation, there's been issues with that. And more specifically, when he picked up this case, he was already on probation in Cuyahoga County. I know that he missed his change of plea date. I personally will take responsibility for that. There was a communication mix-up, but regardless, he did voluntarily show up the next day. It was his trial day, but he showed up what he thought was his next court date. So he wasn't on the run. Nobody had to chase him down. He was arrested because there was a warrant for him, and he did subsequently test positive when he was tested. Your Honor, I know he's got a drug problem, and he has had that for quite a long time. It was my hope that we could get him into some kind of a treatment program, but I know the court's position when somebody's already on probation. I just learned right after we were done in chambers, I don't know if we talked about this in there or not, I didn't pick up on it, but his probation in Cuyahoga County was actually terminated a few weeks ago, about a month ago. So
Yeah, because they said let Lake County deal with it.
Correct, Your Honor, but he technically is no longer on probation anywhere else, so just so the court's aware. Just so the court's aware, I know this is a long shot, but we do have a bed waiting for him. He's on a wait list, I should say, at Lake Geauga. But I also, again, conceded, my client's history. I'm just hoping the court will take into consideration the fact that, he's cooperated. He has shown up to court. He showed up prior, and he did take responsibility in this case. If the court doesn't feel that community control is appropriate, I'm going to ask the court for a reasonable sentence. Thank you, Your Honor.
Thank you. Mr. Morrison, you have the right to address the court before your sentence. You can say anything you want. Is there anything you'd like to say at this time?
Just stand up.
First, I want to apologize for violating my bond conditions. And then second, I would definitely ask for community control, and I will, I can't find it. But I will stick to all the terms of probation. I won't violate any if I could get community control. I'm clean, I'm detox. I've been here for 2 months, and I could keep my system clean, and I maintain employment and all of those things. I just need to get back out and be a service to my family and probably the community if you offer, what's that, man? Community
control?
Community service, man. I could add that also. But, I apologize.
Thank you, sir. Mr. Watson, anything else?
Nothing further, Your Honor.
Ms. Cole for the state.
Thank you, Your Honor. The state does not believe that the defendant is amenable to community control sanctions. When the defendant committed this offense, he was on community control sanctions for a very serious charge, involuntary manslaughter. And while on bond for this case and on community control sanctions in Cuyahoga County, he did test positive when he turned himself in for failing to appear for his change of plea date. And because the state does not believe that the defendant is amenable to community control sanctions, the state's recommendation is a prison sentence.
This court reviewed the pre-sentence report investigation, excuse me, drug and alcohol evaluation. I've considered the facts and circumstances of the offense involved, the nature of the offense. I've considered what's been said here in court by Mr. Watson, the defendant himself, the prosecutor. All this is considered in light of the purposes and principles of felony sentencing set forth in 292911. For the factors in 29-29-12, nothing stands out factually indicating the conduct is more or less serious than normal. As for the recidivism factors, the court finds almost all of these are present. Defendant committed the offense while he was on community control sanctions, has a lengthy history of criminal convictions going back 20 years, has multiple prison terms that he has served. Defendant has also been on probation before and violated his probation, so he has failed to comply with previously imposed sanctions ordered by courts. He violated the conditions of his bond here and continuing to use drugs. Those are all factors. Well, there's obviously a drug abuse problem that relates to the offense as well, and hasn't done anything to address that. No factors indicate recidivism is less likely. Under 29-13B1, defendant previously served a prison term. Prison is consistent with the purposes and principles of sentencing, and there's no way this court can find defendants amenable to community control sanctions based on the history here. Therefore, it will be the sentence of this court that on count 1, defendant served a term in prison of 9 months. He has credit for 61 days he's already served. Count 2 will be dismissed pursuant to the agreement. I'll order the forfeiture of the contraband and instrumentalities. I need to advise you upon your release from prison, you could be placed on post-release control for up to 2 years. If you are and you're violating those conditions, the parole authority can return you to prison as punishment for violating their rules for another 4.5 months. The maximum is 50% of the prison term I just imposed. Any additional prison term imposed for violating post-release control is being imposed as a part of the sentence at this time. The court disapproves the defendant's placement in a program of shock incarceration, intensive prison program, or transfer to transitional control, and defendants order to pay all costs. Ms. Gold, is there anything else for the record?
No, Your Honor, thank you.
Mr. Watson?
Nothing further, Your Honor.